I call the member for Chifley.
Thank you, Madam Deputy Speaker. It's a pleasure to follow my colleague and friend, the member for Greenway, on this. In the discussion of the Standing Committee on Infrastructure and Communications report titled Balancing Freedom and Protection, and it looks specifically at Section 313 of the Telecommunications Act of 1997. And just so that I can clarify, Section 313 allows Australian government agencies, including state government agencies, gives them the power to get assistance from the telecommunications industry when upholding Australian laws. Now, people are in this day and age very mindful of what abilities governments can have to basically impact on the operation of the internet. But there are some things, I think, that the common sense view in the public's mind is that governments should be entitled to act when they believe that there are serious issues, particularly from a criminal perspective, that need to be dealt with very quickly. From a law enforcement perspective, for example, the worst cases of child abuse being portrayed on the internet, people doing truly terrible things that would compel government, and I think the community would expect government to act and act quickly. So there are elements about the way Section 313 operates that are very important and that do need to be, we need to make sure that the operation or the way that it's used by government is continually enhanced, reviewed and improved on occasion. And I certainly commend the report because I think there are a number of elements of the report that do try to recommend a better way of dealing with the operation of this clause. It does also contain a variety of different views. The Communications Alliance, quoted in the report, as saying that it specifically allows providers the ability to engage, this is Section 313, to engage with law enforcement agencies when the matter does not fall under any of the other provisions in the Act or in the Telecommunications Interception and Access Act. And it is also quite a useful provision when the law has not kept up, understandably, with technological development. So that is a positive view expressed by members of the communications industry and Communications Alliance, which I would commend as providing a sensible, reasoned voice within the sector, and they certainly offered their view here. However, there are also contrary views also picked up in the report, expressed, for example, by organisations such as Australian Lawyers for Human Rights, that argue no government agency or officer should be permitted to disrupt online services on the basis that they are potentially in breach of Australian law. There are a diversity of views that exist. I think the argument that is expressed there is that if there is a blind spot within the law, correct the blind spot within particular individual laws, and there is probably some merit in that argument. But until such time as that is achieved, you do need to have a Section 313 operating in the best way possible. And by that reference, best way possible, the reason why this inquiry took the actual form that it did, and one of the big motivations behind this inquiry, relate to an incident that my colleague, the member for Chifley, referred to in her contribution tonight, which was something that took place back in March 2013, where the Australian Securities and Investment Commission had used Section 313 to block websites linked to investment scams on 10 separate occasions, its use being linked exclusively in response to cold calling frauds. Now again, good intention drove ASIC to act in the way it did. I may be making a very big leap of faith there, but I think on a reasonable assumption, ASIC was motivated by good reason to act. But the issue, what happened and what had occurred was that there was massive unintended consequence. What had happened is that nearly 1,000 sites had been blocked as a result of ASIC's intervention back in March 2013. It was claimed that there was limited use and careful targeting. That simply is not based on the evidence. There was inadvertent blocking, as I said, of over 1,000 legitimate websites, including Melbourne Free University. In 2013, around 26 March and again 3 April, ASIC became aware that a serial internet fraud offender was operating fraudulent websites and requested they be blocked. On 4 April, Melbourne Free University becomes aware its website's blocked but they didn't know by whom or why. And when questioned, the ISP revealed only, this is to Melbourne Free University, that the block had been requested by a government agency. So there was this massive impact on a number of different websites, and on a subsequent review of Section 313 requests, it alerted ASIC to a blocked IP address hosting in excess of 250,000 websites. Now, the blocks were removed, but obviously this has forced a great deal of focus on the way this section operates, and the report itself, the committee report, does make a number of recommendations about a whole-of-government approach being utilised to ensure this type of thing doesn't happen again. And it also specifically, I note in the recommendations, it picks up on what happened in ASIC, where there was a belief that particular personnel operating within ASIC didn't have capability or understanding and the breadth of knowledge required to undertake this type of action, and that this inadvertently led to those 1,000 sites being blocked. And the recommendations in this report indicate that that needs to be addressed so that in every agency there is a person with the technical proficiency to be able to manage this. Now, why has my interest been activated on this? Again, my colleague, the member for Greenway, made reference to the fact that other legislation is coming up that will be debated shortly in the copyright realm, and that will provide for powers to site block as well. If we have one section of the law that is being activated to block sites and people have experienced massive disruption as a result of it, the genuine concern would be that if this other legislation were to come to pass and become reality and enable blocking to occur for what is believed to be access to sites that are breaching copyright, then there would be a reasonable concern as to whether or not the type of actions we saw as a result of ASIC's intervention in March 2013 would repeat itself. I think it's a legitimate concern. You only need to look at recent history. Back in August 2013, BBC Radio Times was caught up in a massive block as a result of rights holders pursuing their rights through the courts, demanding that, in particular, internet users who were accessing the Radio Times and hundreds of other websites as a result of a rights holder, in particular the Premier League, had a battle with an unrelated copyright infringing site. The accident occurred because the site shared an internet protocol address with First Row Sports, which offered unauthorised streaming of football games, and the internet providers had been ordered to block the IP address, and because of a simple error, BBC was blocked. And when they approached the actual rights holder to get this overturned, the rights holder indicated that a court action had been enforced and that they were reluctant to actually change the position of blocking, preventing BBC from providing its service to users. This has happened overseas. This is one of my concerns about site blocking. The power certainly exists for legitimate reasons involving law enforcement, but when it strays beyond that, and the capability of certain government agencies to be able to undertake, or, for example, other ISPs being required to give effect to court orders or other legal mechanisms, the question does arise based on previous international experience and local experience whether the capability exists. And this is why we do need to be mindful that when site blocking, if it becomes a reality, it does have the potential to go haywire, and it will be interesting to see who will be left with the can and required to clean up as a result. And so I think, as I said, coming back to this report, there are some sensible recommendations here that I think do need to be taken into account by the government. Given Minister Turnbull made the reference to the committee, I imagine that he is open to these suggestions being put forward, and it'll be interesting to see if he actually responds to the report. Other reports that he has, for example, on IT pricing, he sat on for nearly 2 years and done absolutely nothing about it. But it'll be interesting to see how quickly he actually responds to this and is mindful of some of the recommendations, particularly in the context of upcoming debates we'll have on copyright.